This meeting is a follow-up to our joint briefing on the Lower Basin Drought Contingency Plan of June 28th. At that meeting, we had an ask of everyone to submit questions about the presentations, and then we had a period of time where additional questions could be sent to either CAWCD or DWR. So we're here today to answer those questions, and we will have an opportunity additionally with a handheld mic to have folks in the audience, you all, ask follow-up questions when we give our answers. So we will get into a little bit more of the process for today. But first, for those of you who do not know me, I'm Tom Bushatsky, Director of the Arizona Department of Water Resources, and we'll go around the table here and do some brief introductions, and then we'll turn it over to our Master of Ceremonies, plural over there, who will run us through the meeting. So to my right.
I'm Ted Cooke. I'm the General Manager of the Central Arizona Project. Thanks everyone for coming.
Nicole Klobus, Deputy Chief Counsel, Arizona Department of Water Resources.
Good afternoon. I'm Leslie Myers. I'm the Area Manager for Reclamation's Phoenix Area Office.
Good afternoon. I'm Dan Bunk. I'm the River Operations Manager for the Boulder Canyon Operations Office, also for Bureau of Reclamation.
Hello, my name is Suzanne Tickner. I'm Director of Water Policy for Central Arizona Project.
And so we will have Krystal Thompson and Sally Lee lead us through this presentation. Perhaps you should start by introducing yourselves.
Should I take it now? Yeah. I'm Sally Stewart Lee. I am the Public Information Officer for the Department of Water Resources.
My name is Krystal Thompson. I'm the Communications Manager at the Central Arizona Project.
Well, good afternoon. Let's get started. We received a total of about 50 questions from the public as a result of the June 28th meeting. ADWR and CAP staff have reviewed all of the questions and have grouped them together into categories according to the subject matter or theme. Some of the questions that were sent to us electronically were cut off, perhaps due to limitations of character limitations, so we will do our best to respond to what we believe is the intent of the questions. We received various water-related questions that are not relevant to the Colorado River Drought Contingency Planning. We will not discuss those questions here, but you can contact me at ADWR at 602-771-8530 for those questions.
The main categories covered by the submitted questions are those outlined in today's agenda in front of you. The panel consists of representatives, as you just heard, from the Department of Water Resources, the Central Arizona Project, and the U.S. Bureau of Reclamation, who will address the questions as ADWR and CAP have grouped them. At the end of each segment or theme, the panel will take questions from the audience. For the sake of the schedule, we ask that questions be limited to clarifying or follow-up questions related to those under discussion. Please do not make statements either for or against the DCP or any of the elements of at this event, as the purpose of this meeting is to provide information. The opportunity to provide those comments will come at a later time. There will be time after each segment of the agenda to ask your clarifying questions. We will have a microphone runner in the audience. There are actually two of them who will, if you raise your hand, will come to you for you to ask the clarifying questions.
Okay, so let's get started. The first category of questions relates to the flexibility afforded intentionally created surplus, or ICS, under the proposed Lower Basin Drought Contingency Framework. Questions regarding ICS flexibility fall into two groups: clarifying questions about how ICS flexibility works under the LBDCP term sheet. The term sheet is a working document that the lower basin states have developed and are still developing during their discussions and negotiations to outline the terms of the deal. ADWR will provide initial responses to questions regarding the term sheet. The second group of questions includes clarifying questions regarding the impacts of increased ICS flexibility on Arizona water users. CAP will provide initial responses to those questions. There is also a group of questions that has been designated for response from Reclamation. The first question for ADWR is a two-part question. Will California be able to take more than 4.4 million acre-feet through elevation 1045? Does Arizona versus California need to be amended to allow surplus during shortages?
So I will start by saying that in the presentation on June 28th, we did have several slides on ICS flexibility. They were slides 14 to 17. You can access those slides, that presentation, on either ADWR's website or CAWCD's website. So to be more specific about the question asked, first, yes, California will be able to take more than 4.4 million acre-feet. But to be able to do that, California would have had to take less than 4.4 million acre-feet in a prior year to create that conserved water that they would be taking in a later year to allow them to get to more than 4.4 million acre-feet. And of course, saving that conserved water in Lake Mead raises its elevation and helps keep us out of those shortage triggers in the lake. It's also important to note that the ICS flexibility applies to Arizona as well. Arizona could take delivery of more water than it otherwise could under shortage if Arizona has that same ECICS available in the lake and decides to do so. And then there are some other factors to consider in terms of the DCP and the need to allow California, for example, to be able to have this flexibility to, again, incentivize the creation of stored water or conserved water in Lake Mead. And I will mention that under the decree in Arizona v. California, Reclamation, the Secretary is enjoined from apportioning more than 4.4 million acre-feet to California during shortage years. And rather than reinitiating proceedings in the Supreme Court to amend or modify the decree, the Basin states would seek federal legislation that directs Reclamation, the Secretary, to implement the terms of the DCP, notwithstanding any other law. So that's how we would allow that functionality for that ICS flexibility when we are in shortage conditions in Lake Mead.
Question number 2 is, who is in charge of tracking credits, ICSs?
So again, the question was a little weird, but when we had the ICSs at the end of the question, but we did put these questions in here verbatim. So the Bureau of Reclamation is in charge of tracking those credits. They do produce an annual report, an annual water accounting report, in consultation with each state prior to the finalization of that report. This annual accounting report also tracks the creation and delivery of intentionally created surplus every year. So we do have that ability through that process to weigh in on that accounting as each state in the lower basin.
Question number 3. What is California's current ICS account balance that will be converted to DCP ICS?
So to answer that question, it's important to understand that conversion to DCP ICS would only occur at the request of the contractor that holds that ICS. California has expressed its intention to make its contributions required under the Drought Contingency Plan by converting ICS to DCP ICS, but they could do it in another authorized way. And again, in our presentation, we went through those additional authorized ways to do that. California, at the end of 2017, has an ICS account balance of about 550,000 acre-feet. In recent meetings with California, they have indicated that if there is not a drought contingency plan in place, California may take delivery of all or some of its existing ICS in 2018 and 2019 to avoid stranding the water in the lake. And if you were there on June 28th, you heard us talk quite a bit about this issue, that having the water potentially stranded during a shortage is a disincentive to the creation of the intentionally created surplus in the first place. So it's important to balance that flexibility with some of the backstops that we have in terms of when and how much intentionally created surplus California could take out of the lake.
The next question is, how is DCP and overlay to the 2007 guidelines when the DCP ICS rules are diametrically opposed to those in the guidelines?
So first, I'll start out by saying that the terms of the DCP are not diametrically opposed to the 2007 guidelines. The provisions of the DCP are intended to further the overall purposes of the guidelines, i.e., specifically those that incentivize storage in Lake Mead in order to protect against shortage reductions. Many of the provisions in the 2007 guidelines, such as the maximum annual ICS delivery volumes, that limit how much water can come out of the lake in any 1 year, remain in place. There is maximum storage volumes and other flexibility provisions that are changing, again, to incentivize the creation of ICS storage, again, which will increase the elevation in Lake Mead.
The next question is, so if states can use their ICS to make their DCP contributions, thus continuing to use water at the same rate, even during shortage, then how does DCP? And unfortunately, it's cut off at that point.
So we'll answer it this way. The ICS is created by reducing consumptive use, which at that point, when that water goes into Lake Mead and stays there, it does increase the elevation of Lake Mead and props up the lake. So the states do have to reduce their use in 1 or more years before they can take delivery in a subsequent year. Their ability to recover the DCP ICS is more limited than their ability to recover other intentionally created surplus under the 2007 guidelines. If states convert ICS to DCP ICS, they are restricted in their ability to recover that water under shortage conditions. And reminding everyone that DCP is a whole package that benefits Arizona by reducing the risk of Lake Mead falling to critical elevations that could require draconian water reductions for Arizona. And Reclamation's modeling does show those risks of that happening, and we saw that again in the June 28th presentation.
Okay, so moving now to a group of questions regarding the effects of increased ICS flexibility on Arizona water users. CAP will provide initial responses to these questions. There were 3 questions falling into this category. I'm going to read them all together, and then General Manager Cooke will provide an initial response. Question 1. A framework constructed on building up credits in Mead and broader flexibility to recover those credits at lower elevations seems like a temporary fix that, in the end, creates more vulnerability to the system in general and Arizona and CAP specifically. The vulnerabilities endure beyond the benefits. Question 2. If California is able to take more than 4.4 million acre-feet below 1075, won't that keep Lake Mead at lower levels, ensuring cuts to Arizona through 2057? How does this benefit Arizona? And question number 3, why should water users in Arizona agree to federal legislation allowing California to take more than 4.4 million acre-feet when Arizona is taking a shortage?
This grouping of questions gets at the overall question about what is the benefit to Arizona of DCP and specifically California's participation if it has a flexibility to do what's described in these questions, which is to, number one, borrow or recover ICS that is stored in Lake Mead while the lake is in shortage as defined by the 2007 guidelines, and number two, to convert its ICS into DCP ICS and cover its contributions that way. And I think number three, after the 2007 guidelines and DCP terminate in 2026, there's some tail provisions that if California still has ICS or DCP ICS in Lake Mead, that under certain conditions it will be able to withdraw them even after 2026. So let me start there. As Director Bushatsky said earlier, that California's stated intention is that they will meet their DCP contribution obligations by preloading the system, by storing water in Lake Mead ahead of time, and that's what their stated intention is, and in fact that's what they're doing. That's how that 550,000 acre feet that Director Bushatsky referred to of ICS that California currently has, that's what that represents. When we began these discussions on DCP in 2015, California had less than 100,000 acre feet of ICS stored. So they've already basically started on this. If we get to the point in time, 2026 or later, that California still has ICS in Lake Mead or DCP ICS in Lake Mead that they could potentially withdraw under those rules, that to me is a good thing. That means that they put more water into Lake Mead than they needed to satisfy their DCP obligations. The ability to withdraw that was part of the flexibility that California asked for to justify for them putting ICS in the lake in the first place. So if that situation exists, once again, California would have put enough water in the lake to satisfy all of its DCP contribution requirements under DCP and have some left over that they would be entitled to take out later. The conclusion that after 2026, as the question says, that would require Arizona to continue to take cuts, I think that's speculative because we don't know what the program would be after 2026. There won't necessarily be any negative impacts from California recovering that ICS, and I would remind everyone that the recovery of pre-2026 ICS or DCP ICS would be at much higher elevations than during the period of time where DCP is in place. With respect to California's ability to recover ICS and take more than 4.4 million acre feet, once again, it's really the same answer. To be able to do that, to take more than 4.4 in a year, whether or not anybody else is in shortage, California would have had to take less than 4.4 in a previous year in order to be able to do that. And that same flexibility, as Director Bushatsky said, also is available to Arizona and Nevada to do the same thing and have that same level of flexibility. Our modeling has shown that in general, even with the availing itself of the flexibility to pre-store ICS and take it out or convert it, that having California in DCP is a better thing overall because California will make its contributions by doing so, even if there's some puts and takes in between. I'm looking over to the staff to see if they have any additions to that. No.
Okay, thank you. We will now have time for a few minutes of follow-up questions from the audience about responses provided to the questions you heard about intentionally created surplus flexibility under the Lower Basin Drought Contingency Plan framework. So we have staff on either side of the room that have microphones. I see a hand in the middle.
Will California sign and commit before Arizona signs and commit to the DCP plus?
California has said that many times in public that it's ready to go. We have not, however, worked out the exact timing of who goes first. I expect whoever gets there first, and with the some kind of comfort level that other folks are going to get there soon, that's the order that those things will happen.
So, Mike, I think I'll answer that by saying there are boards in California that need to give their approval to their organization signing on to DCP. That could happen before we have final approval in Arizona, but I would expect some kind of date at which we either all sign or it all becomes effective all at one time. So signing and committing it really will be effectuated by their board approvals, and then a point in time in which everyone's signature makes the agreement enforceable and puts the agreement in place.
I would draw everyone's attention to, as an example, the Minute 323 that was executed late last year. Is that the individual approvals of the parties, the second-tier parties that had to execute agreements and things like that, all happened in kind of a serial fashion, and then there was a placement in force ceremony where all of the official signatures were affixed to the document. So we've done this before, so some process like that probably. And it will be, when we get there, something similar to that, where it will be a ceremony, I'm hoping, because it will, A, be over, and B, be a good thing that we did.
Do we have any other questions about this first segment? Oh, okay.
Does Arizona currently have any ICS storage in Lake Mead?
Yes, we do. And first of all, there's several different categories of ICS, and I won't get into all that. But Arizona currently has, I believe, pending final validation, I guess is the word that I would use, by the Bureau of Reclamation, around 200,000 acre-feet of extraordinary conservation ICS in Lake Mead.
Other questions? I see none. Okay, the next category of submitted questions relates to protecting Lake Mead below elevation 1025. As with the ICS questions, these questions also fall into two groups. Questions regarding how the term sheet would be implemented to protect Lake Mead below elevation 1025, and questions about the risk to Arizona water users regarding protecting Mead elevation below 2015. ADWR will provide initial responses to the first group of questions. We are going to read all four together, and then ADWR will provide an initial response. What actions have the parties committed to regarding what DWR refers to as the backstop? In the term sheet, does any party commit to make additional reductions? If so, who, when, and how much? Isn't the commitment to protect 1020 just an agreement to agree, i.e. totally unenforceable? Under what authority would the SOI reduce Arizona uses when there is sufficient water to deliver to lower basin users? And what is the legal basis for protecting elevation 1020 or 10,000?
So those are largely legal questions in my mind, so I will defer to Deputy Chief Counsel Nicole Clovis.
Thank you. The commitment in the Lower Basin DCP represents the first time that the Lower Basin states would identify a particular elevation as requiring protection through collective action. This provision would put Arizona in a better position to demand collective action at that time. We have not, within the Lower Basin DCP, identified what specific collective actions, by whom, in what volumes, would take place, because if and when Lake Mead falls closer to elevation 1030, We will have more information about the necessary reduction levels, as well as how best to implement those reductions. Without the DCP, there's no legal basis for protecting an elevation 1020 or any other specific elevation in Lake Mead. The lower basin state principles identified that elevation because below that level, there may be little time to act to avoid declines to dead pool, likely imposing draconian reductions on all water users below Lake Mead. As for the Secretary's authority to impose reductions, I will defer to Reclamation.
If you want to go now.
Thank you, Nicole. Under the 2007 guidelines, the Secretary has already determined a schedule of reductions to lower basin water users, including Arizona uses. In the event that the basin states agree to implement the drought contingency plan, the basin states have indicated, as Tom said earlier, that their intention is to seek additional congressional direction for the Secretary to specifically implement DCP.
Can I just, I'd like to just supplement the, not Leslie's response, but just to clarify what the term sheet says about the protection of lower elevations. And the term sheet really is not gonna, it won't offer up a legal basis for protection of mead elevation. What it provides is that the parties agree to get together and consult about what additional collective action may be required. But there's no definition about what that action may be. So I just wanted to make sure that the audience understands we're not creating new legal authority for actions to protect Lake Mead at certain elevations. The parties are committing to additional collective action at those elevations, and the who, how much, and when will be determined when the consultation provisions are triggered.
And I'll just add that, you know, the DCP is another incremental step forward in the management of the river. I think Suzanne mentioned this at the end, but when we get into the trigger point for that discussion about the additional actions, that's the point in time that we'll be able to determine the volume of water that potentially needs to be looked at for those additional actions. So it would have been very difficult to try to project out as we negotiated the DCP how much water we needed to come up with to further protect the lake, and then to try to negotiate specific actions around a volume of water that was unknown would have made that even more difficult. And again, to some degree, the DCP is an incremental step in terms of what we could actually accomplish collectively at this point in time, knowing that we might have to take additional actions to add on for the next increment of protection for Lake Mead.
Okay. So a related question that was submitted inquiring about the impacts and risks to Arizona water users related to protecting Lake Mead below elevation 1025 will be addressed by General Manager Ted Cooke. What happens under the law of the river at elevation 1020 or 1000? What is the risk to Arizona?
I think without being completely redundant for the answers that we heard from the other panelists here, I will repeat that the law of the river as it relates to elevation 1020 and 1000 is only what the parties have agreed to in the 2007 guidelines. And if we get to that point, what we agree to under DCP, which is this consultation together to decide what actions we will take collectively if the lake is projected to reach those levels. But it does not, at least in my mind, modify any of the rest of the law of the river with respect to these levels, that this is now some new levels at which some defined thing will happen, and other than this consultation. And I think that was what Suzanne said, and also what Tom said. The 2007 guidelines already provide that a consultation will occur when Lake Mead is approaching elevation 1,000. So the DCP will add this addition, kind of a higher level at 1020. This type of consultation will occur, and furthermore goes on to say, and the parties will have a conversation about what they need to do individually and collectively next, even though it doesn't define what that is. I'd like to remind everybody that the whole point of doing DCP is to reduce the risk that the lake will get to levels of 1025 and below. And one of the main reasons for that is while the 2007 guidelines and DCP define what will happen as far as reductions to deliveries at 1075, 1050, and 1025, it does not specify what will happen after that. There's a lot of uncertainty. We all want to avoid that. We can't make the probability of that go to zero, but we can get it much closer to zero than it is right now by doing DCP. So it's difficult to answer, well, what happens at 1020 and what happens at 1,000? We don't know. But we've committed to, as Director Brushatsky said, with the other participants in DCP to get together, talk about it, and determine about what it is else we're going to do. Under both the decree, the Supreme Court decree, Arizona versus California, and the Colorado River Basin Project Act, the Secretary's authority to impose restrictions based on CAP's junior priority are only operable when there is insufficient mainstream Colorado River water to deliver the lower basin's apportionment of 7.5 million acre feet. That situation does not exist at 1020 or at 1,000. So while Arizona will participate in DCP and Arizona will participate in the conversation about what to do if the lake gets to those levels, we do not interpret those reductions as being an imposition of Arizona's junior priority because the conditions are not met of not having enough water to deliver to everyone. However, we are part of DCP. We will be part of whatever happens if the lake does get that low. While there may be no legal requirement under the law of the river to protect a specific elevation, such as 1020, both, again, the 2007 guidelines and the DCP are intended to slow down the decline in the lake and bend the curve so that the lake can slow down declining and avoid reaching these critical elevations of 1025 or lower. The risk to Arizona is that if insufficient mainstream water is available to deliver 7.5 million, then the junior priority would kick in, but we don't expect it to happen at those levels of 1020 and 1,000. That will be risk not just to Arizona, but risk to other folks if the lake gets to that level. So I'll circle back around again and say that's the point of DCP, is to join together with the other lower basin states, the U.S. and Mexico, to reduce the probability significantly that we will ever get there and have to find out what happens.
Okay, we now have a few minutes to provide for any follow-up questions from the audience about the responses provided to questions about protecting Lake Mead.
With climate changes upon us in every single state, how are you going to calculate the evaporative rate of all the water sources so that those who want to take out their water that you stated how much they had each state, how will that be calculated with evaporative loss? There may not be that there for them to take.
The evaporation, actually, it's a good question. The evaporation in the major reservoirs, particularly Lake Mead and Lake Powell, which is where most of the evaporative losses occurred, I'm sure it's calculable. The technical folks can answer that. But a calculation is not what is used to determine, from an accounting perspective, how much intentionally created surplus that is stored in Lake Mead will be reduced each year to account for evaporation. It is an agreed-to percentage that's specified in the 2007 guidelines and then modified slightly in the DCP of what those evaporative loss assumptions are. So that we don't have to do a calculation. We agree that we're going to take this evaporative loss assessment for any ICS that's created and stored in the lake.
So I'll specifically refer back to the presentation on the 28th. So under the 2007 guidelines, there's a 5% assessment in the year creation for the system benefit and a 3% assessment every year thereafter for evaporation. Under the DCP, again, getting back to disincentives for storing water in the lake, there's a one-time 10% assessment, both for system, the benefit of the system, and for evaporation. And for existing intentionally created surplus, the assessment will bring that number up to 10%, and then there will be no additional assessment through 2026. So the DCP has simplified that evaporation assessment as I described it. And again, it's in the presentation from the 28th.
Ted, I did not feel very confident in where we're going as far as the water levels and what we might or might not be able to do. That was not very confirming. I've been boating on Lake Powell for 40 years, and I've seen the water there in the 80s be stable, close to full pool at 3,700 feet. Since then, it has been going nothing, as you're well aware, down, and that's where we get our water from. I'm not confident in any of these arrangements as far as protecting Arizona. What are we doing in the big picture, such as maybe desalination, talking to California or Mexico about being able to do something there to trade water by desalination? Sooner or later, we're going to run out of water. There's no doubt about that with global warming.
So I'll take that as specifically to desalination discussions. So minute 323 to the 1944 Water Treaty, Ted mentioned it earlier, was signed September of 2017. One of the items in that minute was to explore opportunities for a binational desalination project in the Sea of Cortez. The minute asked, or the minute had a work group propped up to put together a scope of work by March of this year. That work group has met probably a half a dozen times. I am the U.S. co-chair of the work group. My counterpart in the state of Sonora, Mexico, is the co-chair for the binational work group on that issue. We will be moving forward with that process as described in a minute through later this summer and throughout the fall. So those discussions have taken place and are ongoing. There's also, in relation to other opportunities within the state, Governor Ducey's Water Initiative created a Water Augmentation Council that has several elements to it. One is a desalination work group looking primarily to desalinate brackish groundwater within the state. There's also an augmentation group looking at things like enhancing recharge, forest health in a environmentally sensible way that might result in more yield in some of our in-state rivers, and other opportunities. There's a recycled water committee looking at ways to improve and reuse our reclaimed water through indirect potable reuse and even direct potable reuse. So we have different fronts in which we're looking at augmenting our water supplies, and we do have that ongoing process with Mexico for a binational desalination project. And that might be moving the water directly across the border. It might be moving that water back up to the Colorado River in a way that exchanges with Mexico's treaty water could happen, and all of those issues are still in flux at this point in time.
I would add to Tom's answer that even though the focus of these discussions that we started late last month and we're following on today is on the drought contingency plan, that is just one tool in the toolbox. It is a way to manage our Colorado River resource in times of drought and impaired supply, basically. But that does not mean that we're not doing anything else. And I think from Director Bushatsky's answer, you can see that we are also focusing on how do we augment supplies, how do we find substitute supplies. There will be a point of time with any single supply that you're going to not have enough for everybody that wants it, and if we haven't already reached that point already. So we don't want anyone to leave thinking that we think that this is the silver bullet that's going to take care of all of our problems if we do this. This is just the next thing that we need to do, and there will be other things that we need to do simultaneously with this and more things that we need to do after this. But this is the one that's front and center right now that we need to do first.
Ted, you had talked about how it was your opinion that the Secretary's authority to institute their own shortage reductions or whatnot didn't really kick in until there's insufficient main stem water to deliver the water under the agreement. My question is there a level that is sufficient, or do they just keep delivering water until it's dry?
It is. This is treading into legal interpretations and things like that. But I'll give it a shot, and then we've got a whole rest of the panel and some other experts sitting over off to the side here. But as defined in the decree and also the Basin Project Act, the insufficient supply, insufficient compared to what? Insufficient compared to the lower basin state's apportionment of 7.5 million acre-feet. Of course, if there are agreed to reductions in those apportionments under the 2007 guidelines or the DCP based on the elevation that Lake Mead is at, then that quantity, at least in my opinion, would be reduced as far as what is a sufficient amount that would be needed. I don't know what the exact level is, but at least of Lake Mead, but at least under the 2007 guidelines, assuming that the hydrology would support it, the minimum release from Lake Powell is between 6 and 7 million acre-feet all by itself, and Arizona and Lake Mead does not reach dead pool, meaning that there's nothing able to be released out of the lake until I think 895. So there probably is, quote unquote, sufficient water to make all of the deliveries above that level, and that is why we need this type of voluntary. It's voluntary until we all agree to do it. This type of cooperative program to have an agreement in place of what are we going to do before we get to that point.
So I'm going to come at that, I guess, from a different non-legal way, and it's this. We could probably argue different legal theories till we're blue in the face. One of the benefits of this drought contingency plan, there's a path forward without having to have those arguments necessarily. I don't want to see a situation where federal marshals are going out to turn CAWCDs or anyone else's tap off the way they've done in the Klamath. That's the train wreck scenario that Commissioner Berman talked about on the 28th, a path of litigation, a path of chaos. That's not in any of our interests, and polarizing the states against one another in that situation where we're trying to interpret what the decree or the Basin Project Act says in relation to sufficient supplies, et cetera, it doesn't seem like the place that we want to be ending up in.
So I'm just going to add add some numbers to the specific question, agreeing completely that we don't want to find out. Nobody wants to find out. And that's one of the purposes and reasons of the DCP, so we don't have to go there. But at elevation 1,000, there's approximately 4.33 million acre-feet in storage in Meade. The law of the river also considers water available for release from Powell in that year. So you can do your own math about what releases we could anticipate from Powell to say there would be sufficient water for 7.5 million acre-feet. And I'm not saying that anybody wants to be at elevation 1,000. I'm just putting some numbers to answer your question about how much water is in storage when we're at elevation 1,000.
Okay, so several questions were submitted seeking additional modeling and analysis of the drought contingency plan. CAP will provide the initial responses to these questions. The first two were essentially the same, so I will voice them together. Can DWR and CAP model the impacts of the drought contingency plan without ICS recovery flexibility and without California contributions to show how this scenario, quote, bends the curve? And California's actual participation in DCP contributions appears to be less than guaranteed. What does the, quote, curve look like if California does not participate?
I'll start with the answer on that one. CWCD and ADWR and also the Bureau of Reclamation are evaluating how to go about doing that type of modeling. We're working on it. Have not completed that work yet. We will continue on it, doing that. It's a difficult question to answer of what would DCP look like with California not in there. There are boundary questions such as, well, if California didn't participate, would that fail to activate Mexico's contributions under their water scarcity plan or not? If California didn't participate, would someone else need to step in and do that instead? There's reference in the question to bending the curve. The curve gets bent by all of the parties to DCP making their contributions. The curve would be less bent if California did not participate. So that's the general answer, is that just intuitively, if any one of the parties does not participate in the DCP, the curve will be bent less, and the probability will be reduced less than otherwise would happen. And that was the benefits of DCP versus only the 2007 guidelines were covered in the slides at the June 28th meeting by Regional Director Terry Fulp on pages 8 through 12 of the presentation. We will continue to define what California not participating might mean and what kind of assumptions would represent that, and work together with ADWR and the Bureau of Reclamation on attempting to model that.
Okay, the next question.
So there was another part to that question.
Okay. Yes.
About California's participation is not guaranteed. And I will just say that California's contributions to Lake Mead under the DCP will be guaranteed. It will be a legally enforceable document. The Secretary, again, through federal legislation, will be directed to implement operations on the river pursuant to the DCP. And Arizona has no intention and will not enter into a DCP agreement where there's no guarantee that California is going to participate.
Okay, the next question. What is the benefit to CAP users from DCP versus the benefits to other lower basin users?
That's a difficult question to answer. The benefit that we all share is the reduction in the probability that, and the risk that Lake Mead will reach the critically low elevations of 1025 and below, and at which point it becomes somewhat unpredictable, or actually a lot unpredictable about what might happen after that point. And that's why the DCP includes this higher elevation of 1020 provision, for the parties to consult and decide what else to do individually and collectively next. So that is the benefit that we all share. There are other benefits that the individual states and parties within those states would receive from doing DCP, and that would be in exchange for taking less water, they get something back. It's difficult for us to identify or quantify what the benefits would be to California, the parties in California, or Nevada. That really is, and the term I use is kind of in the eye of the beholder. I would encourage everyone in Arizona to evaluate what the value of DCP is to Arizona by looking at what the cost to Arizona is. Is the benefit that we get sufficient for the cost that we have to incur to do it? I think, in my opinion, it's fruitless to say, are we getting a better deal out of this than somebody else? Because I don't think there's an answer to that question. Because we're not the somebody else. We're not getting the same benefits necessarily. There are differing contributions specified in DCP to the 3 lower basin states. They are not proportional to the allocations of each state, nor do they all occur at the same elevations necessarily. At this point, those arrangements in the DCP term sheet are relatively confirmed among the 3 states that this is the way that it's going to work, and the work that we have to do in Arizona is to evaluate how can we make that work here. I guess I'll just end the answer there.
Just a little detail about the eye of the beholder for the state of California. One of the benefits that they were seeking and they would be able to achieve with respect to the ICS recovery flexibility, the ability to recover ICS during shortage below elevation 1075. MWD in particular is looking for the ability to recover ICS as a supplemental supply if they're suffering a shortage in their Northern California system as well. So that's a unique benefit to the state. Each state has unique circumstances. That is one of the benefits that the deal provides uniquely to California.
And I'll just add as well, on the 28th, I talked about prior reclamation modeling, looking at different hydrologic scenarios, showing potential lower basin reductions, 1 million, 2 million, and bigger. If you just do the guideline reductions, then you hit elevation 1025 or elevation 1000, and you say no more. One of the other things that the technical group Ted mentioned earlier, DWR, CAP, and Reclamation is looking at is updating some of that modeling, and we'll have that information available to folks when that is completed.
The next question, who is protected by DCP in Arizona?
Several times in today's meeting, we have referred to slides that were used at the June 28th meeting, and I'm actually going to ask that the slides be turned on so that we can use them, a couple of them today. In the meantime, I want to caution folks on the use of this word protect and what exactly does that mean. First of all, it's an uncertain future. We have lots of historical data that we can use to define what the probabilistic future might look like, but there's no certainty about what is going to happen. So when we use words like protect, it does not mean this is absolutely protected, this is going to always be available at 100%. So I guess if I had a chance to rephrase that question, I would say, who is most protected, or whose supply becomes the more reliable, I guess, if that's not breaking some grammatical rule to use 2 adjectives in a row like that. So the first slide here compares, to remind everybody, Arizona's 2.8 million acre-foot supply. Right now, about 1.2 million acre-feet of that is used on the river, and the rest, or 1.6 million acre-feet, is used by CAP and its contractors and subcontractors. Most of the supplies on river are priority 1 through 3, and in the reductions defined by the 2007 guidelines and the DCP down to level 1025, the only reduction on river would be the P5. It's about 5,000 or 6,000 acre-feet, I believe, if I remember correctly. And under shortage sharing recommendation from ADWR, the P4 water reductions would be borne in large part by CAP users, not by the on-river users. So on the river, which supplies are the most protected or made the more reliable are those dark purple there, that priority 1 to priority 3 water, and also the priority 4 water on river because of this shortage sharing recommendation. I'll go to the next slide now. Within CAP, the horizontal lines that are being superimposed there are the reduction tiers under DCP when added to the 2007 guidelines. And they're annotated there. It goes from 192,000 acre-feet at elevation 1090 down to 720,000 acre-feet at elevation 1025 and below. The colored blocks there represent various priorities of CAP water that goes from the highest priority at the bottom to the lowest priority up top. And it's intuitive by looking at this slide is everything below the last dotted line there are the supplies that are the most protected under DCP in Arizona, which would be the Indian priority water and the M&I priority water, and of course all of the priority 3 water. It's not very much relatively, all of the priority 3 water. So to summarize the answer again, on river, it's a P priority 1, 2, 3, and 4 that are the most protected under DCP. And within the priority 4 water of CAP users, the Indian priority and M&I priority water receive the most improvement in their reliability under DCP.
So I'm not going to add to Ted's answer, but I do want to editorialize a bit. Ted mentioned the director's shortage recommendation about the shortage being shared between the P4s on river and the P4 within CAWCD. And I just want to mention that that creative solution that was put together by DWR was actually put together in a public process where municipalities, et cetera, within CAWCD staff, DWR staff, and representatives of the folks on the river got in a room and worked out the deal. And the details of the deal aren't that important. The fact that the deal could have been worked out to create some mutual benefits and avoid conflict, I would call it, about interpretations of how much the on-river would take versus how much CAWCD, gives me great hope that as we move forward in this process, we can create similar creative situations or come up with creative situations like that in this process to help make the DCP possible within Arizona. The shining example of something that we've already done. Again, that was 2005, 2006 timeframe, but we did it then, we can do it again.
The next question, could Arizona take voluntary actions without DCP, similar to the pilot system conservation program actions that would reduce the risk of, quote, catastrophic shortage?
This is a question we spent quite a bit of time on in the June 28th meeting. I think theoretically, could Arizona take voluntary actions on its own to do this? Probably theoretically it could be done. But the real question would be is, would we do it and why would we do it? One of the slides that we showed, and hopefully, can you put the slides back up, please? There we go. One of the slides that we showed, and that was page 8, it was part of Director Bushatsky's presentation there, shows the contributions required by each of the lower basin states, the Bureau of Reclamation, Mexico, and in the case of the 3 lower basin states and Mexico, it breaks out the quantities of reductions or contributions that would be made under the 2007 guidelines, and then the additional quantities under DCP and the totals. I would direct everyone's attention to the purple column all the way over there to the right that shows what the total reductions that would be made among all the entities, including the guidelines and the DCP. As the lake continues to decline, the contributions go up and up and up, and this is how the curve is bent. And when we use that term, it literally means when you see the modeling projections that the curve of the level in Lake Mead does this. Hopefully everybody at home can see that too. Does this as the lake declines and the contributions under the guidelines in DCP increase. At the bottom there, 1025 and below, 1,475,000 acre-feet is the cumulative contributions there. Could Arizona do that? Sure, but it would be giving up the entire CAP supply at 1025. And the point of DCP and the 2007 guidelines is to not have to do that. And earlier in today's meeting, I expressed at least CAWCD's opinion that the junior priority does not begin to apply as long as there is water to deliver to the lower basin states. So could we do it? Yes. Would we do it? No, because that would entail giving up the entire CAP supply. And why would we want to do that if the Arizona contribution by itself would be 720,000 acre-feet at that level, and the rest of it, another 700,000 acre-feet, is coming from everybody else? We would have to make that up to get the same results. So I hope that's a sufficient answer. Could we do it? Yes, but I can't see any logical reason why we would do it.
So we now have time for audience questions about the responses that you just heard about additional modeling and analysis. I don't see any. Oh, I see one.
If you give up all the water or the 1.4 or the 700, what's the economic impact on the viability of the CAP and the resulting impact on the taxpayers in the Tri-County area?
I don't know that we've done such an economic evaluation as to conclude what that might be. Yeah, Tom reminded me that several years ago we did in conjunction with Arizona State University, an economic study on the value of CAP water, Colorado River water actually, being brought to central and southern Arizona through the CAP canal. And on the average, every acre-foot of water, of Colorado River water brought into central and southern Arizona is worth to the economy about $60,000. So simple math, you could take $60,000 and multiply it by whatever quantity is on this graph and say that's the economic impact of these reductions to Arizona. But I would remind everyone, I think that's an oversimplification, because the $60,000 number, that doesn't just represent that an acre-foot of water is delivered to somebody and that person or entity is enriched by $60,000. That's the entire economic value to that individual or entity, and how that individual entity invests in the community, and them, and them, and them. So it's this multiplier effect that takes place. Plus, that figure of $60,000 per acre-foot represents the average over all of the economic sectors in the state. I think that part of our challenge in implementing DCP in Arizona is to find a way to optimize the reductions, at least taking into account what the optimal economic outcome would be of taking those reductions. So I don't know what the answer is. I can give you a scoping number by doing that math that I just did. It's a lot, but if we want to arrest the decline in Lake Mead and have some of our supply left, we're going to have to figure out a way to do this, regardless of the high cost.
Any other questions? Well, before we head to our break, I wanted to thank a few members of our state legislature for joining us today. We have with us Representative Dunn, Senator Mendez, and Senator Atondo. Thank you for joining us. We also have some legislative staff. In addition, we have a number of members of the CAP board in attendance. We have Vice President Jim Hallway, Karen Caesar, Alexandra Arboleda, Pat Jacobs, and Mark Taylor. So thank you all for coming and being here. Now it's time for our break. We have 15 minutes. So I would say 2:25, plan to be back for the next segment.
The next grouping of questions relates to how the Lower Basin DCP would be implemented in Arizona and its effect on water users. The first two questions are for the director. Question number 1, in relation to DCP, will the Arizona Conservation Plan still try to stay out of shortage and above 1075?
So with the Drought Contingency Plan, tools like system conservation and tribal ICS need to be in place to incorporate conservation when it makes sense to do so. It doesn't look like over the next few years, with the way the lake is going, we saw the probabilities of going to shortage 70–80% that Reclamation showed us on June 28th. It doesn't appear that we're going to be able to prop up Lake Mead enough to keep it above 1075, at least not without some significant help from Mother Nature. And the Arizona Conservation Plan needs to be really flexible because we may end up targeting keeping the lake above 1050 if it keeps declining the way it has been declining. So we need a really flexible plan that allows for the analysis of the practical capability of conserving a volume of water that's actually going to do some good for us in protecting various elevations. So that's generally, I think, what the Arizona Conservation Plan will look like. We have a lot of work to do in terms of the details of what it will actually turn out to be, and that will be one of the 4 main cogs of the steering committee discussions moving forward.
Question number 2. If the shortage levels in the 2007 guidelines were the most Arizona believed it could manage, then why does Arizona now think the much larger DCP shortage levels, and then it's cut off with just an A?
So we're not really sure the premise of this question is correct. I'm not sure that the shortage levels in the 2007 guidelines were the most Arizona believed it could manage. Those guidelines were developed through a whole bunch of different modeling and a process that found the process that resulted in a bending of the curve then to single digits for the lake falling below 1025 and other critical elevations in that time period of the 2007 guidelines. So I really look at this question more as how will Arizona be able to absorb the increased reductions under the Drought Contingency Plan? And again, the steering committee process is designed to look at ways to do that and to partially mitigate the incremental impacts of the Drought Contingency Plan within Arizona. Again, the possibility of voluntary agreements that don't undo the priority system and don't undo the flow of water to the priority system, but through those voluntary agreements help mitigate or partially mitigate some of those impacts to those lower priority users to the benefit of the higher priority users, as Ted described earlier, who are being benefited by the Drought Contingency Plan.
The next question relates to how the Lower Basin DCP would be implemented in Arizona and its effects on water users. This question is for General Manager Ted Cooke.
Can we put the slides back up? This one.
Okay, but I need to say the question.
Oh, okay. I'm all ready with my answer.
I know you are.
Can you hurry up, please?
Yes. Mr. Cook's presentation seemed to presume that DCP contributions would be made in order of priority, with the lowest priority CAP users being required to contribute all of their supplies before a higher priority user made a contribution. Is that necessarily how the DCP is envisioned to work? Isn't one of the benefits of the DCP that contributions could be made in a way that is more flexible than the priority system through which shortages are applied? Also, isn't there a potential for users to be compensated for their DCP contributions? It seems misleading to add together shortage volumes and DCP contribution volumes and then show them as supply deficits affecting users in order of priority.
Okay, this hopefully folks could see why I wanted this slide to be put up before the question. We spent, this is another thing that we spent quite a bit of time on at the June 28th meeting. I think the way that we described it, that without any of the voluntary agreements that Director Brushatsky described a moment ago in place, that what would determine these shortages under the 2007 guidelines, and if we implement DCP, the additional reductions under DCP would be mandatory. So at the various levels that are shown on this slide, we would in Arizona receive that much less water. And without some other approach through these voluntary agreements, the reductions would be made in reverse priority order. In other words, the lowest priority first, and then the next, and then the next, until all of the reductions would have been satisfied. That part of the question says, is that how the DCP is envisioned to work? It could work that way, but it is not how we're envisioning it working, because as Director Brushatsky said, there is a need to attempt to mitigate some of the lower priority users who are going to suffer the most through the addition of DCP to the 2007 guidelines. So yes, our intent is that there would be some of these voluntary types of agreements where higher priority water users might modify or reduce their use so that more of the water that is available to Arizona, it won't create any more water, but more of the water that's available to Arizona could flow through the priority system to lower priority water users. And in that way, Arizona as a whole would be able to meet its contribution to the lake and find some means to use all of the water that's available to us in the way that makes the most sense to us as a community. I would like to, though, build on Director Brushatsky's comments that those voluntary arrangements, and we've been doing those types of things since 2015. Without DCP even in place yet, we have been doing what we call DCP-like contributions in Lake Mead already. But that has not been accomplished by simply eliminating the lowest priority water users until we have 192,000 acre feet to make those contributions. Higher priority water users have participated in that, and that has done both of those same two things. We've made our reduction, or made our contribution into Lake Mead, and had some water available for lower priority users as well. So we hope that the same thing would be true going forward. But any of those type of arrangements will actually use the priority system rather than be a replacement for the priority system. It's important to understand that distinction, that we're using the priority system to allow the water to flow through the priority system rather than saying, let's just ignore all that and set that aside and do something different. We can do something different, but it needs to work within the framework that we have so that we don't inadvertently set a new precedent or violate a contract provision that somebody has. We find a way to do what we need to do within the framework that we have.
We will now provide a few minutes for any follow-up questions from the audience about the responses provided to questions about implementation of the Lower Basin DCP in Arizona. Do we have any questions?
Right, no, Ken.
So I have a question about what you just discussed on this priority pool. It sounds like up to this point that some of the higher priority, meaning the Indians in the cities, have voluntarily agreed to let some of the water flow up to lower priority agricultural pool. And if that's the case, as this scenario mead gets lower and lower, what guarantees that that will continue to happen? In other words, if it's all, that it'll be, both sides will voluntarily agree to that, or will there be some kind of, certainly, let's say, binding, or will there be a battle from the two cities versus farmers into the legislature with no one making any decisions? In other words, how is this going to be implemented in a mandatory fashion as you get lower down the water chain here?
That is we hope to avoid that situation of any kind of battles on the one hand or lack of decision on the other hand. This is the reason that Director Bushatsky and I have convened this whole process and are beginning in 2 weeks our stakeholder process. We'll talk a little bit about that under next steps as we end the meeting. So we're convening about 40 water use representatives across the region to work with us on working out those type of arrangements in advance. There is no guarantee that that will happen, but it's our distinct hope that it will. We've already had practice doing these things successfully for the past 4 years, and we need, these quantities are increasing. We're going to need to do more than that, or the result will be that somebody perceives that they're being stuck with the outcome of doing DCP, and that will make it much more difficult to have the folks coming together when we do go to the legislature and say, we all think this is a good thing, let's do it, please approve it. Microphone, here it comes.
Can you hear me? I still think we need desalination, and we need it in the fashion of like a Marshall Plan, where the federal government gets behind it for the 4 states that are in the lower basin, and either puts it in California or puts it in Mexico, and each state contributes to it financially to pay it off. Because I'm not hearing anything here that tells me long-term, with 85,000 people moving into Arizona every year, that we've got a long-term solution. The only long-term solution I can see is getting more water. And a Marshall Plan, which would be interior-wise within the United States, would be not an easy, but a solution.
Any other questions? Okay. The next set of questions share the common element of inquiries best answered by the Bureau of Reclamation. The first question is, what % of evaporation change with surface area reduction of Lake Mead? Or what is the %, sorry?
Okay, thanks. I'll address that question. Estimated evaporation volumes change proportionally with changes in water surface area, and the water surface area changes along with changes in elevation. For perspective, Lake Mead's estimated evaporation volume at elevation 1075, which is about 540,000 acre feet, is about 1/2 of the evaporation volume when Lake Mead is at full reservoir pool. When Lake Mead is at full pool, evaporation is over 1 million acre feet.
Why is the Bureau now using stress test hydrology?
The stress test hydrology, which is based on the period from 1988 through 2015, is more representative of what we have been experiencing in recent decades and does not include the wetter years of over 100 years ago, back in the early 1900s. The concept of using more recent information originally came from water users in the basin, and use of stress test hydrology has been developed in consultation with the 7 basin states. The stress test hydrology has been employed in the analysis of actions to better protect the system in both the upper and lower basins.
How does the United States plan to meet its commitment to contribute 100,000 acre-feet a year? How will that be enforced?
Thanks, Krystal. Dan and I are going to trade off a little bit on our responses here. We answered this question at the 28th meeting, and I will just reiterate that today. The U.S. doesn't have a Colorado River allocation, so I know it seems difficult for us to be able to contribute 100,000 acre-feet. Reclamation, acting on behalf of the United States, could implement several different programs. We have a couple options. We could do something similar to the Pilot System Conservation Program that we've been participating in for the last several years. We are working on the development of something we call the 242 well field in Yuma that could help provide additional system water. And we've also looked into running the Yuma desalting plant. We anticipate that the U.S. contribution would require some combination, probably, of these, and potentially some other new programs that we could come up with in the future. These actions are all dependent, of course, on federal authorizations and congressional support. We have already committed $15 million in federal funding to the Pilot System Conservation Program and about $21 million to the development of the Yuma 242 well field. So we've had some support in prepping for this. Of course, you know, we can't make specific commitments in the future, but I think that we heard from the commissioner that the United States is interested and willing to continue to participate as long as we are able and we get those authorizations and congressional direction. So I think the way Dr. Fulp put it on the 28th was we are pledging our best efforts to meet our DCP commitments.
The next question, when will the tribal water study be released?
Nicole just reminded me, and I thought I was going to do this anyway, that I should talk about just for a minute what the tribal water study is. The tribal water study that is referred to in this question is the Colorado River Basin 10 Tribes Partnership Tribal Water Study. It's being conducted jointly by Reclamation and members of the 10 Tribes Partnership, and it builds on the limited tribal assessment that was completed in the Colorado River Water Supply and Demand Study in 2012. So the study, the tribal water study for short, has been ongoing for a couple years. Most of the technical work is completed. It is currently being reviewed by the Department of Interior and representatives of the 10 Tribes Partnership. Completion of the study is of priority for Reclamation and for the 10 Tribes Partnership, but as of today, we don't know exactly when it's going to be released. The review has taken a little bit longer, I think, and the discussion's ongoing than we had originally anticipated. I believe we had thought that it would be out in June, and now that we know it's July, it was not released in June. So it will be up on our website when it's done.
What will the Bureau's role be in any projects that may be coming out?
Okay, so this is a little bit of a guess here on this response. So if somebody wants to follow up with this later, we'd be happy to elaborate. I think I talked a little bit about the ongoing work that we've done with the 242 well field and with the Pilot System Conservation Program. I just want to say that Reclamation's been very committed, especially over the last several years, to working with the lower basin states and specifically with Arizona on projects to help to help mitigate negative impacts within Arizona to DCP will continue as long as we are supported by Congress and by appropriations. We are hopeful that we'll be working with you all through this process.
I'm going to read the next 3 questions all at once, so bear with me. The first one is, why isn't the U.S. enforcing Section 4 of the Boulder Canyon Project Act, which requires California to provide 375,000 acre-feet toward the Mexican treaty obligation? The next question is, why does Arizona have to take bigger shortages while the U.S. continues to ignore its obligation to replace bypass flows at Yuma, having cost Lake Mead around 2, and the rest of the question, I'm afraid, is cut off. And the last one is, if the Secretary of the Interior won't follow the law of the river today, then why should Arizona believe a future secretary will? And then it's cut off. The last part of the question is the junior priority?
These issues involve the interest of the United States and each of the 7 Colorado River Basin states that share the Colorado River. These issues, along with many other related issues, have been and will continue to be discussed among the 7 Colorado River Basin states, the Department of Interior, and where appropriate, the Republic of Mexico. The ongoing lower basin negotiations, including the development of this DCP for the period through 2026, are premised on longstanding positions and best efforts towards collaboration and compromise among the states. The issues raised in this question are expected to continue to be addressed with the other basin states and as a part of a longer-term discussion affecting the basin as a whole. We don't believe that these are issues that can be resolved in this intra-Arizona discussion.
Okay, thank you. The next question is, can you clarify the statement of amending or changing SAWRSA settlement allocation? What are you proposing and what does this entail?
Okay, so the SAWRSA, and I'm not sure I've ever said it that way, that referred to as SAWRSA, or the Southern Arizona Water Rights Settlement Agreement. And I will say up front that I apologize because I even went back and tried to watch the video of the 28th meeting, and I didn't hear a discussion about SAWRSA. But what I do want to clarify is that the implementation of DCP will not reopen any negotiations or affect any tribal CAP allocations.
You can tell I'm a newcomer. What is the role of tribes in shaping and implementing the DCP?
This is another question that was answered preliminarily at the 28th meeting. And I think the thing that we want to emphasize that tribes are essential participants in the implementation of DCP. They're major water users of Colorado River water at all priority levels. In fact, nearly half of Central Arizona Project water is set aside for permanent allocation to Indian tribes. To date, the tribes have been major players in the Pilot System Conservation Program and have expressed interest in participating in the intra-Arizona efforts to mitigate the negative impacts of DCP to lower priority CAP water users. Option for future flexibility in internal Arizona agreements will likely depend heavily on tribal participation.
And the next question is, has a feasibility study ever been done on Lakes Mead and Powell to use floating solar panels to reduce estimated evaporation on both lakes, about 1.7 million acre-feet annually, and provide additional electrical power, about 15% more efficient on water versus land? Has soliciting bids to install them ever been done to non-governmental contractors?
Thanks. I'll give Leslie a break on this one. Floating solar panel platforms, which could cover portions of water surface areas of reservoirs, was one of the options to reduce evaporation analyzed in the 2012 Colorado River Water Supply and Demand Study, or the study. The study assumed that 10% of the reservoir surface area in major reservoirs, including Lake Powell, Lake Mead, and Lake Havasu, could be covered, resulting in up to 200,000 acre-feet per year of reduced evaporation at full reservoir levels, at an estimated cost of approximately $15,000 per acre-foot of water saved. And this is a conservative estimate, I believe. While reducing evaporation would likely increase reservoir levels, key considerations to resolve include ensuring technical feasibility, overcoming logistical challenges, such as the fact that these are large reservoirs and have a lot of environmental conditions, such as wind, rain, etc., permitting, legal and policy issues, and potential impacts to recreation and the environment.
We will now provide a few minutes for any follow-up questions from the audience about the responses provided to questions for the Bureau of Reclamation. Do we have any questions?
Yes, are the tribes required to participate in the DCP? And if they are, would they be able to use their unexercised water rights to participate?
Can I ask you to repeat the second part of that, if they are?
What part of it? Would the tribes be able to use their unexercised water rights to participate?
Thank you. I think one of the things that both Ted and Tom pointed out in the beginning was that once Arizona opts in, the reductions are going to be imposed upon Arizona, and they are going to be imposed upon the lower priority water users. So I think that the tribes would be required to participate in the event that they were within a priority pool that would be affected. I think that many tribes have volunteered, understanding that they are likely outside of the priority pools, or at least at the lower level of reductions, and have wanted to help. I'm not sure if Tom's pointing back at me, but the question about unexercised rights, I'll throw it to you.
So I think your question about unexercised rights might get at, can tribes participate in conserving water in Lake Mead through either system conservation or intentionally created surplus with unexercised rights? The answer is no. So to participate in those programs, you have to actually reduce water that you would otherwise be using. And so there's a strong policy and history of not allowing marketing, so to speak, of unused water entitlements, not just for tribal water, but there are other entities that have Colorado River water in the state who don't use all their water. And likewise, they have not been able to use that water to participate in system conservation or intentionally created surplus. And I think that's a really important policy to move forward, because if that were allowed to happen, then you're magnifying and expanding the impacts on a group of different groups of water users if you allow that to happen.
I think I'll add one comment to those two answers. Whether it's tribes or whether it's any other Colorado River water users in Arizona, Arizona is using all of its 2.8 million acre feet today. And that is because that unused water by senior water users flows to the next priority, as Director Bruschowski just described. So we're using all of the water. So it's not as if any user that's not used, that has some unused water entitlement, that somehow is being kept in reserve or something like that. It's being used today. So for anyone to say, hey, I've got some unused water that I would like to contribute, it's already being contributed because it's being used by somebody else, and it does not diminish the amount by which Arizona is going to have to reduce its overall use under the DCP.
Is the term sheet that was mentioned earlier available to the public? And if so, where can it be found?
That's actually a question coming up. Shall we answer it now, or do you want to wait and answer it when we get there?
So the basin states are currently drafting several agreements that would constitute a whole drought contingency plan package. And we do not have currently complete drafts that accurately represent the full package of all the terms for the Lower Basin Drought Contingency Plan, although we certainly had full discussion of the concepts in order to describe them. So that's shorthand for my lawyers, and other lawyers in other states are doing their lawyerly thing in drafting. We hope to have full drafts available for discussion in the coming weeks, and we'll share those when we are ready to do so and when they are completed.
Okay, so the next grouping of questions includes questions that did not fit neatly into any other category. So we created a category titled Procedural and Miscellaneous. The first question is for General Manager Cooke. Are the slides from the June 28th presentation going to be posted for download?
I told the moderators that I had to have at least one easy question, and this is it. Yes, the slides from the June 28th presentation are going to be posted. They were posted, I think, a day after the June 28th meeting. And in fairness, a lot of these questions today we've answered and said, yeah, we already talked about this, and these questions were collected from the beginning of the June 28th meeting to the following Friday, the Friday of last week. So there probably were a lot of questions that people thought of that they asked before we got around to answering them. This is one of them. So please, no one take the answers that we gave saying we talked about that as being dismissive, or we did talk about it. And so this is a chance to further explain those type of things. This is a question where I'm pretty confident this person asked this question before the slides were posted. But yes, they're there. They're on Tom's website. They're on the CAP website as well. You can find them.
The DCP is very important to adopt. It doesn't look like enough, though. Is anyone working on an even harder proposal to avoid shortages?
Tom's question that came before this one he already answered, which was what about the term sheet? So that's why I'm going two in a row. The DCP is very important to adopt, but the asker of this question has posed a very important point. Is it enough? Most likely not, and I think some of the earlier answers that you heard today reflected that. One thing that we haven't talked about today, but we did talk about at the last meeting, was that the guidelines themselves specify reconsultation needs to begin prior to the end of 2020. Reconsultation on the guidelines. They expire in 2026. DCP will be coterminous with the guidelines, so the next thing will be arise out of that reconsultation. There needs to be something. The guidelines themselves, the DCP will be stepping stones to that next thing, and it's impossible to predict today whether or not that will be more, but that's likely that will happen. In addition to that, we've had some conversation today about what else are you working on besides the DCP. There needs to be more stuff, and there is. We're looking at desalination, both local desalination and ocean desalination, and there's both supply and demand management that we need to do, and there are multiple tools in each one of those buckets, and we are working on all of those things.
And I'll just add, Ted talked about the stepping stones, and I'll point to a couple of really important ones. One is, again, some commitment that when we get to low elevations in the lake and potentially larger shortages or larger reductions need to be made, that we're going to do that collectively. It's not going to fall on Arizona alone. And also despite the fact that California can conserve water ahead of time and use that for DCP ICS to meet their obligations under the DCP. Any kind of paradigm in which California is agreeing to take less than 4.4 million acre feet is a really important stepping stone moving forward into the renegotiation of the guidelines, because I would have told you 5 years ago that was never going to happen. As early as 2014, just a couple years ago, when we were working on a different DCP type proposal, that was not on the table at all. And so we've come a long way. That's an important precedent. We also are one of the other stepping stones that also is implicated here is the structural deficit. So the long-term reduction, or the long-term situation where we get more water coming out of Lake Mead than we do in average years coming into Lake Mead from Lake Powell. A very contentious issue for our friends in the Upper Basin. The DCP doesn't directly resolve the structural deficit, but it certainly dampens down the impact of it, and certainly we expect that to be an important stepping stone moving forward to show progress to the Upper Basin in the renegotiation of the guidelines, that we've done something during this interim period through 2026 to help offset some of the impacts of the structural deficit. So I think those are really important factors when we analyze what the value of the Drought Contingency Plan is for Arizona.
The next question is for the director, and it's a two-part question. Is Arizona's legislature required to sign off or approve the DCP in some way? Are legislative members' leadership being briefed on this information?
So the answer is yes. The legislature must act to give the director the authority to sign onto the Drought Contingency Plan on behalf of Arizona. Arizona is unique in that situation as compared to California and Nevada. Those parties do not require state legislative approval. There are water users within those states, boards that have to approve their entities signing onto the DCP, but not the state legislatures in those states. We do have Arizona legislators participating in the steering committee process moving forward. Our goal is to finalize that intra-Arizona component related to the Drought Contingency Plan approval before the end of 2018 so that the legislature can act early in 2019. So we understand how important it is to have the legislature involved in the discussions, and we have invited them. There will be 4 members, again, participating in the steering committee, kind of at ground zero, building something from the ground up. Something we heard loud and clear down at the legislature in this past session, that they wanted to be more involved from day one in any solutions for the state in relation to the Drought Contingency Plan, and we will make that happen.
The second part of the question you've just probably already answered, but the second part is, and how can Arizona act this year given the need for legislative approval of DCP? What can CAP and ADWR do this year?
So since this is cross-examination, I'll say asked and answered, but seriously. We describe what we're doing. The meeting on the 28th, this meeting today, are part of that process. The first steering committee meeting coming up on July 26th is the next step in that process. So we're moving forward to try to meet the goals that I described earlier.
We will now, oh, excuse me, sorry.
Just one thing. One thing that I will add to specifically on the question about what can CAP and ADWR do this year, and I would add everybody else. What can they do with CAP and ADWR this year? So to get to that point of bringing a proposal or a agreed upon DCP recommendation to the legislature, we will need to define a lot of the mechanisms, these so-called voluntary agreements that we talked about before, and how those things, this is going to be part of the conversation in getting to that point that will become part of DCP later. So we will actually be in the work that we're doing this year to arrive at the point where we can go to the legislature, doing a lot of the work about the implementation itself once we have DCP in place.
Okay, now we will provide a few minutes for any follow-up questions from the audience about procedural and miscellaneous questions. Are there any questions?
Thanks, Candace. Can you tell us what is planned to be rolled out on DCP during the Colorado River Water Users Conference?
I'm not sure I quite heard the whole question. Was it, what is the plan to roll out the DCP at the Colorado Water Users Association Conference? So I think that would be one of the target dates in which we might take some action at that conference. Traditionally, some major steps forward in the management of the river have been taken at the conference, the signing of the guidelines in 2007, for example. So since the legislature doesn't meet before then, certainly I would not have the authority to formally sign onto the Drought Contingency Plan, but I believe that by that point in time, we'll have a pretty good idea of whether or not we have successfully created that intra-Arizona plan. The legislature will have been involved. We would certainly confer with them, but there is a possibility of doing something like this. So in Indian water rights settlements, when the state has participated, the state has signed onto a statement saying that the state supports the settlement. The state will help move this forward. Other parties have done the same, making a commitment to bring the settlement to their boards for approval, and that was kind of a condition of the settlement legislation being dropped in Congress. Something like that, something less than a full commitment, we might be able to sign on to by the Colorado Water Users Association date. I would hope that we can do that, but again, that's contingent upon a successful intra-Arizona plan and support of the folks in the legislature who are participating with us to make sure that it doesn't look like we're getting out in front of the legislature before they have time to deliberate when proposed legislation comes before them. So I am hopeful that we will be there by that point in time.
So this is a question about how much water Arizona has banked, and for the director of the CAP, I know we bank a certain amount of acre feet every year along the CAP into the strata. And so my question is, if the DCIPS goes forward, legislature passes it, will forbearing water from Lake Mead so the levels remain higher require us to stop the water banking, which is what I read in the Republic, and at what risk does that put Arizona in the future?
So I'll start. So approximately, the Arizona Water Banking Authority has approximately 4 million acre feet stored. Some of that's for Nevada. And there's another 6 million acre feet stored by various entities around the state. So there's 10 million in total. The recovery of that water banking, the Arizona Water Banking Authority at least, is for situations where mostly municipal and industrial priority CAP subcontractors are seeing reductions. Some of the P4 on river folks are seeing reductions, and some tribes. In terms of the DCP ending up at a place where there's no more water for the water bank, that's where we're heading anyway. If we go into that first level shortage, which seems more likely, that water will be gone anyway. And again, if the lake does recover and that excess water becomes available once again, the Water Banking Authority potentially would be a recipient again of some of that excess water. And so I'll also mention for Leslie's benefit that the federal government has an obligation also to firm tribal water supplies. They have relied on that excess water pool largely for that effort, and they'll be losing that supply as well, and we'll have to find other means. The water bank does have the authority, which the water bank got a couple of years ago, I can't remember the exact date, to go and purchase long-term storage credits from others who have created them. That's one mechanism for the water bank to continue to do its business. So I don't know, Ted, do you want to add anything?
I think so. Not maybe specifically with respect to the water bank or any other water user, and this gets back to the slide that I had up there on answering my last question. One way to implement DCP in Arizona is to go from the top down, lower priority to higher priority, and just start saying, you don't get any, you don't get any, you don't get any, you don't get any, because you're the next one in line. I think collectively we hope to avoid that by not having a situation where some folks go from some amount of activity, whatever it is that they might be doing with the water that's available to them, to nothing, and everybody else stays at 100% necessarily, but find a way for everyone as much as possible to continue on the activity that they're responsible for to some degree. We're going to have less water as a state coming from the Colorado River. And again, the answer is somewhere between. You just go in order, or we find a way to kind of rejigger things through the priority system to allow as many folks as possible to continue with the water-based endeavors that they have. So it doesn't have to be this complete black and white outcome necessarily. But this is something that we all need to agree to, and it's not necessarily a majority rules or so we don't have a rule for how this is going to work. It's going to have to be a multi-party negotiation, and Tom and I will get a little bit more into that in next steps about how that will work and who's going to be involved in those discussions.
My understanding is the other 6 states have their contingency plan completed. If that's correct, why are we the last and really down to the last hour to get this done?
Well, I think that it would not be accurate to say that everyone else has the plan completed and approved. The other states are prepared to approve. They have implementation plans as necessary developed within their states. California has a somewhat complicated issue for implementation interstate, just like Arizona does. I think they have the broad outlines of an implementation plan negotiated, but they have not signed any agreements. And as Director Bishotsky mentioned earlier, we are still drafting the overall package of agreement documents for the overall drought contingency planning for all 7 states. So no one has actually approved or signed any of the agreements. When we talk about the other 6 states being prepared to move forward, that means that they are prepared to approve documents once they're finalized, and they have implementation plans ready to move forward with.
I have a couple of questions about the steering committee, which you may plan to answer during next steps, but specifically, what is their purpose? What is their expected product? What is the timeline? And how are they to be selected?
We can answer that question now, I think, and we were going to cover some of that in next steps, so maybe we'll cover all of it now, I don't know. The steering committee, I will answer that last question first. The steering committee, first of all, let me preface that with the steering committee meetings will be like this. Maybe not with the exact same setup, but they will be open to anyone who wants to come. We will have some means of recording them like we do here, so they will be, in that sense, a public meeting. However, we will not have 150 people having a conversation. There would need to be a smaller group than that. So Tom and I, this gets to the last question. Tom and I have jointly selected individuals to sit on the steering committee, and each of those individuals will represent a certain constituency within the Arizona water community. The invitations to those invitees, delegates, I think we're referring to them, went out last week. We are still in the process of receiving RSVPs, so until we get confirmation from the folks that were invited that, yes, they're available to serve, we're not going to publish a list, but we'll do that as soon as we know what that is. The purpose of the steering committee will be to have the conversation and come up with a implementation plan for DCP within Arizona. So that will focus on, at least to start with, the four, we talked about this on June 28th, the four essential elements that Tom and I have identified so far that need to be part of the conversation, which is tribal ICS, excess water, an Arizona conservation plan, and I always do this. I never can remember all four at one time. Help me. Oh, ag mitigation, yeah. So I don't always forget them in the same order, because it depends on which one I start with, as which one is the last that I don't remember. But it's those four things that need to be part of that conversation. That will also incorporate these discussions about these voluntary agreements, I think, that will be part of each one of those four things, or maybe things that need to be added to that list. Our timetable is going to be at the outside, the beginning of the 2019 legislative session in January. A question came up before about, is there going to be an announcement at CRUA? Lots of people would like this to get done before the end of the year. We are going to be on a pretty fast track to even meet the CRUA expectations. Tom and I and Leslie and our staff were sharing before this meeting began that between June 28th and today, July 11th, or 10th, whatever day it is, well, it's like being on a treadmill. The 10th, somebody help me out there, 10, yeah. It's the 10th, and this is what our life is going to be between now and the end of the year, is every couple of weeks meetings with a lot of work to do in between. But we're committed to it, and we expect to meet that deadline one way or the other.
I'll just add a couple of things about what the work product will be. So I think the resolution that will be in front of the legislature to give the director the authority is relatively straightforward. And we have had past resolutions that would be similar for Minute 323 and Minute 319 and the 2007 guidelines. It remains to be seen, in my mind, as we put together the Inter-Arizona plan, what other agreements that might have to be signed off on, kind of legally binding. We heard a question before about the certainty, about how some of this might work. The question was about the certainty of having municipal water go to agriculture, I think, but there may be some of those things that are needed to give the parties the certainty that they need to then be able to support the drought contingency plan approval in front of the legislature. But we don't know what that is yet, and that will become more evident as we work through the process in the steering committee and various proposals come forth among the delegates of that steering committee. I will also say that Senator Griffin and Representative Bowers have been helpful with Ted and I in discussing how to engage the legislature, and I think that's a really important piece of the steering committee, again, them being there and their representatives being there from day one. So when Ted said we've chosen the representatives we have, but it hasn't been in a vacuum. It's been with input from folks like that in other situations.
All right, the agenda is now calling for next steps, any other next steps, and closing remarks.
So I don't know, Ted, if you mentioned that the steering committee meeting is July 26th from 1 to 4 at CAWCD headquarters will be the first meeting. We're trying to make sure that we have a room big enough that we can have substantial public participation. And that's going to be difficult. We're going to have 40 people or so around the table needing to make sure. So we're going to be needing to find pretty big venues to make sure we can accommodate as many people as possible so the public can observe and potentially give input through some kind of call to the public type of process as part of the steering committee.
We do not have an agenda yet for that meeting, but that is our top priority. As soon as we're done with this, we're going to, Tom and I and our staff, be working on what the agenda is so that we can have a productive discussion on the 26th and every meeting thereafter. Actually, there's no time to spare, as you can realize in the schedule going forward. I don't know if we have any other next steps besides that at this point.
So we missed someone who wanted to make a comment. Okay, so maybe if Tony could give him the...
My name is Velasquez W. Sneezer Sr. I'm a former vice chairman of San Carlos Apache Tribe, a former councilman back in the 80s, and a current councilman serving the San Carlos Apache tribal people. I have been involved in this water rights so many times. And I see here discussion continuing about the water. I would like to submit this comment on behalf of the 16,000 members of San Carlos Apache Tribe. I submit my comment on the Lower Basin Drought Contingency Plan. As discussion continue on the plan, I urge you to consider that our tribe is deeply concerned about the drought, which has adversely affected the San Carlos Apache Reservation and its people and lasted nearly 20 years with no perceivable end in sight. As we all can agree, water is life. Any plan to address the continued drought and falling level in Lake Mead is vital to Arizona's future. We recognize that 3 tribes currently participate in the LBDCP, but our tribe's interests are different and should be included. Please keep in mind that our tribe is concerned that any agreement in this arena will include any cuts to Indian entitlement to Central Arizona Project, CAP water. These entitlements are rooted in the United States government's trust responsibility to protect this tribe's asset, including water rights that were confirmed in federal law, water rights, settlement agreements, and priorities. The Arizona Department of Water Resources and the Central Arizona Project should, we believe, recognize and include all affected tribes in the process. We understand that a steering committee is being created at this time. Because of the devastating impact of the drought in Indian country, I request that all affected tribes, including our tribe, be made part of that steering committee. Affected tribes deserve to have a place in the development of the plan and can and should be part of the solution. Accordingly, our tribe seeks to meet with you in the days ahead. We look forward to being included in the joint efforts of all of Arizona to help finalize and implement a feasible Lower Basin Drought Contingency Plan. As we say in our Apache language, "Hia," which means thank you, in advance for your consideration of my request on behalf of our tribe. Sincerely, Velasquez W. Sr., Gilson Wash, the tribal councilman, and for Terry Rambler, the tribal chairman. We are here the same as you. We need water. We need to know how we should also participate in this plan. And that's why we're submitting our statement, our comment today. And thank you all.
Thank you.
So our next steps are concluded. Today's event is concluded. Thank you all for spending your time with us and having the open minds to hear the answers to these important questions. If you have any questions followed on to this meeting, you're welcome to send them to Sally Lee or myself, Krystal Thompson. Our emails are on both of our websites, and you can talk to either of us after the fact. Thank you.